Section 57. Equity regards the beneficiary as the real owner. Equity regards the beneficiary as the real owner. In a court of law, in a case of an express trust, the beneficiary is not recognized. I'm going to repeat that again. In a court of law, in case of an express trust, the beneficiary is not recognized and has no rights the trustee is bound to respect. No rights that the trustee is bound to respect. On the face of the deed, the legal title is in the trustee, and the courts of law will look no further and will hear no proof on behalf of the beneficiary. Indeed, if the beneficiary is in possession, the trustee can eject him by suit in a court of law. In short, in the eye of the law, the beneficiary is not known. Read that again. In short, in the eye of the law, the beneficiary is not known. And that's making reference to 72 footnotes, which is second-story equity jurisprudence, sections 964, 968, and second Pomeroy's equitable jurisprudence, section 979. Continuing on, but in equity where the intent of the grantor and not the form of the grant prevails, the beneficiary is regarded as the real owner, and the trustee is considered as a mere manager of the trust property for the benefit of the beneficiary, and liable to the beneficiary for any and every breach of the trust. If the trustee fails to do his duty, the Chancery Court will remove him on proper application. And all this is true not only of trusts created by wills, deeds, or other instruments in writing, but also true of trusts created by law. Also true of trusts created by law. Thus, every administrator, executor, and guardian, and to a less extent, every clerk court, receiver, sheriff, county trustee, or other public officer entrusted with the money of others by the law, and especially where he has given bond to secure those entitled, is liable to be called by the beneficiaries to account in chancery. And in all such cases, the court regards the beneficiary as the real owner of the property. The courts regards the beneficiary as the real owner of the property. Although the legal title is in the officer having it in his possession, but while the Chancery Court regards the beneficiary as the real owner in order to more fully to guard his interests and assert his rights, it also regards him as the real owner as to his liabilities, and except in cases where the trust is declared by a will or a deed duly registered, will subject his interest in the trust property to the satisfaction of his debts, and on proper bill filed for that purpose, as hereafter shown. In dealing with the beneficiary's interest in the trust property, equity follows the law and treats such property as descendable, divisible, and alienable. Also in cases of trust, including trust deeds, assignments for the benefit of creditors, and even constructive and resulting trusts, the Chancery Courts are ever ready to lend a helping hand to the beneficiary as against him who holds the legal title. That's the end of the section. Now from that can be plainly gleaned that there are two separate divisions here. The one division at law, one of the two separate streams or two separate jurisdictions or two separate venues that the beneficiary is recognized in. And the other one, which is the equitable one, instead of the at law, is where the beneficiary is recognized. And I suppose it's conversely because everything is opposites and equals. Therefore, it could be said that the at-law side trustee might not be seeable in the equity part, especially if that trustee was, say, an attorney who was representing solely just the at-law. But anyway, the issue is really that there are two separate venues, two separate jurisdictions, and the one from the one side can't be seen in the other side. So whichever side that you pick looks like the other party can't be seen in the opposite side. But the true owner of the whole shebang is really the equitable side, the beneficiary, who holds the beneficial interest. And he's considered to be the true owner of the whole thing, but yet he can't be seen at law and has no say at law, only the trustee. So here all along we've been going into the wrong courts for all these years, arguing the at-law side and wondering why we never could get our substantive rights adjudicated and actually win. But now through the eyes of NTT and the eyes of equity, we understand here why you can't win because it even says in all the equity books there is no adequate remedy at law, and now we understand why. But yet, like fools, everybody continues to go into the at-law side, hammering in a new way, thinking that if they keep on doing what they've been doing, eventually it's going to work. And like fools, nothing changes. And we think if we tweak our paperwork just a little bit better, or if we put a little bit more emphasis in it, or we do a little bit this, or maybe if we hold one foot up higher than the other, or maybe if we call down fire from heaven or throw a little more water on it, maybe that will make it work. Well, maybe that God is dead, or maybe he's sleeping, and you people over there worshiping that side, maybe you better wake him up and scream a little louder over there or something. Maybe he's just sleeping and not paying attention to you. Or why don't we go over on the right side and start worshiping the right God and calling out to him, and what he says he'll do. You got to look at these two sides as being totally the opposite. Don't confuse your reactions or their actions, what they did on the at-law side, how they acted towards you, what they did to you, what they called you, what they did to you over there on the at-law side. Do not confuse that with the opposite side, equity side, because I think that you're going to find out that it's exactly opposite that. Shouldn't be fearful to go in some place of a court that was designed for you to bring your substantive rights into and get fairness and justice and equality, which is under equity, the equity side of the court. Naturally, you should be fearful of going on the at-law side where there is no substantive rights, there is no fairness, there is no justice. Everything operates in an opposite, topsy-turvy, upside-down world. You should be fearful of that. But the other side, you shouldn't. And all this time we've been doing the wrong side of the court. We've been going into the at-law side, going in there and arguing our rights and our redress of our grievances. And here we've been, all these years, going into the wrong side of the court. Wrong side of the court. But now we know differently. Since they've combined the process of both sides into one process, which is probably the 90 or 86 rules, or your local state's civil procedure rules, to get into either side of the venue by the proper form, and they probably use the same forms, but it's the substance you put in the form, whether or not you're claiming equity or not. Because the procedures have been merged, the forms are probably maybe the same, but it's the substance you put on the form that actually invokes the court, invokes the court of equity. And if you don't put in the right switches, by default, it's considered a general deposit, which is the at-law side. And you waive your substantive rights. And you become the fiction by going in there and arguing. You become the fiction. Didn't have to do that. You could go on the equity side and stay out of fiction land and stay one of the people. So why don't we open it up for Q&A.